Lesandro Guzman-Feliz, also known as Junior, was a teenager with a bright future, a close family, and plans to pursue a career in law enforcement. In 2018, at the age of 15, he was mistaken for a rival gang member and was brutally killed. A group of young men chased Junior and pulled him out of a Bronx bodega where he was stabbed with knives and a machete in a brutal attack that was caught on camera. Jonaiki Estrella was convicted of first-degree murder and sentenced to life without parole for his part in the murder. He had delivered the final machete blow that took Junior's life. The story shook the community and was widely reported across the country. In a shocking decision in 2023, a New York appellate court threw out the first-degree murder conviction against the Trinitarios gang member, ruling that prosecutors failed to meet the high bar for proving torture, triggering the first-degree murder charge. In February of 2024, the people brought this case to a higher court to prove the elements of torture. Let's take a look.
Reva Grace Phillips for the appellant, the Bronx County District Attorney's Office. Your Honor, may I reserve 2 minutes for rebuttal?
Yes.
Thank you. In reversing defendant's first-degree murder conviction for the brutal slaying of a 15-year-old, the appellate division erroneously found that the people had to prove multiple actions within the course of conduct individually inflicted extreme pain, and the defendant's post-slaying statements not only evince pleasure, but evince pleasure, quote, for its own sake.
So yeah, help me with the record. How is this different from a gang beatdown? I don't think your position is that every gang beatdown is torture. So how is this different?
Your Honor, this is distinguished in a number of ways. From the outset, this is a planning meeting where defendant's present along with his gang mates. They received this order to go out and target at random a member of a rival gang. So I think from the very genesis, we have a very wanton crime in the sense that there is no definite target. And in fact, the defendants don't even bother making sure that they've caught someone from the rival gang before they brutalize this 15-year-old boy. So from the very outset, I think you have a particularly wanton crime that they are set out to engage in. The second thing I would say is, again, you have the misidentification. So this isn't, a discipline of a gang member. This is a misidentification.
So is it your position that the 10 seconds that we see on that video, is that separate and distinct acts, or is that one entire act? How do you see that?
Yes, Your Honor. So I would say that is a collection of separate and distinct acts. However, if the core question there is where does the course begin, we would argue that the course begins at that planning meeting.
Okay, so if there's separate and distinct acts, how many of those separate and distinct acts have to cause extreme physical pain? Is
Absolutely.
One enough?
Yes, Your Honor, one is enough. Under the plain text of the statute, one is enough.
Okay, so if one is enough, couldn't you charge that for every murder where that involves a chase or some kind of, beat down, to use Judge Rivera's words? If it's only one act to cause extreme physical pain in a series of acts, would that satisfy?
If one act in a course of conduct inflicts extreme physical pain, that could satisfy it. I think there would be other factors to consider here. For instance, another factor that we have here are defendant's post-slaying statements, which I think stand out for not only the people's access to that evidence, which we got through a cooperator, which is in and of itself a unique way to access that evidence. It's rare evidence to have.
To make sure I'm understanding your position, the course of conduct can be exclusively up until one blow, completely no physical contact. It could be we're planning what's going to happen, and as long as there is one physical act which inflicts extreme pain, that's enough. The course of conduct isn't the course of inflicting the pain?
That's correct, Your Honor, and the plain text makes that clear. The course of conduct inflicts or intends to inflict torture, and torture includes the infliction of extreme physical pain. And to clarify that point...
So the course of conduct inflicts the pain. Isn't there an argument that the most natural reading of that is that there are a course of actions, each of which is inflicting physical pain, as opposed to I'm going to plan for an hour and then take one action?
Well, again, I think the plain text says the course of conduct inflicts, which refers to the whole course and whether or not it inflicts extreme physical pain in its totality. So that could be achieved through one blow. And I think that we can look to other statutes to know that...
So you could charge a fist fight that results in a fatality, right?
Yes, Your Honor.
You
if
could.
there was a fist fight that ended in a fatality,
Yeah.
and there
You would
was
say the
evidence...
course of conduct is the series of blows. Each one is a piece of that conduct. There is a course, because there's more than one, and that's then an A1 felony.
Well, Your Honor, again, you would still have to prove the defendant's depravity and the infliction of extreme physical pain. So we wouldn't contest, for instance, that where a singular blow immediately kills a victim, that constitutes torture.
So
The victim's not alive.
let's take a single gunshot wound, and it takes the victim a half an hour to die, and, there would be no question but that there was extreme pain inflicted. With respect to that, if there is some course of planning that precedes it, is your view that that would suffice? And if so, that seems like it sweeps in a very broad swath of conduct.
So, Your Honor, again, there would be more factors to look at. Again, depravity, I think, is a real limiting factor beyond the course of conduct question. So it would be depravity. For instance, if a defendant...
But the action itself, in other words, a single gunshot wound, the victim doesn't die immediately but dies 30 minutes later, that would be sufficient in terms of the course of conduct inflicting extreme physical pain.
Yes, Your Honor, and to take your own example and run with it, I think you could have a defendant who intentionally wounds someone in a way that they know will be fatal and they know will take a while to cause that fatality, and that's absolutely within the ambit of the statute. Having a defendant, for instance, who shoots someone here, for
Are you
instance-
saying that's within the ambit of the statute without even a course of conduct preceding it?
No, Your Honor. Again, I would assume the factors course of conduct and the factor of depravity to get to the core of Judge Halligan's question there.
But the course of conduct, just so I'm clear on this theory, the acts that make up the course of conduct can be, I think, as you said, planning, having a meeting, riling up the troops, any number of things whose ultimate goal is to inflict that one depraved coup de grace that would make it torture. Is that right?
Yes, Your Honor. I believe that under this statute that would be correct. And again, I think we do have other statutes where the legislator makes a numerosity requirement. For
In
instance,
this particular instance, if you took out the planning and you focused on finding this particular victim and the conduct that took place leading up to, would that qualify as a course of conduct?
absolutely, Your Honor. And I would argue that even if this court finds the planning meeting is not the beginning of the course of conduct, that you could look next to the chase, that you have, again, a series of distinct acts for the unified purpose of brutalizing this child.
So it's the unified purpose that one focuses on in continuity for course of conduct?
Yes, Your Honor, and I believe we cited in our brief to People versus Payton, which this court favorably cited, and I believe People versus Ublink. But the series of distinct acts, it's not really a temporal question so much as are there a series of distinct acts for a unified purpose? So we would argue that's what a course is.
Does it matter how much time takes place for a course of conduct to have happened?
No, and again, Your Honor, we know that the legislator is comfortable making those requirements where they feel they're appropriate. And in the course of sexual assault of a child, for instance, there is both a numerosity requirement and a temporal requirement. The abuse must take place over more than 3 months, and it must include at least 2 distinct acute incidents of abuse. So we know that that's often results of an ongoing series of interstitial abusive grooming tactics. But the legislator felt comfortable saying you have to have 2.
So are you relying here on the conduct, the other knifings and the machete, or simply on the final blow? Tell me exactly what you think counts as part of the course of conduct.
Absolutely, Your Honor. So we believe the course of conduct begins with the planning and continues all the way through the fatal blow.
I mean, in terms of the physical activities alone, which ones count?
So, all of the blows, again, the chase is very physical. There are folks getting out of their cars trying to chase this boy as he tries to hide in the hospital, chasing him to the bodega, pulling him out by his body, beating him on the way out.
Is that because those actions, in your view, inflict extreme physical pain, or because they culminate in the infliction of extreme physical pain?
So I would respond with 2 points, Your Honor. One, again, the course is about having a unified pattern over the series of distinct acts. So whether or not they inflict pain, they can be a part of the course. The second thing we would say is under the standard before this court today, the question is, could a reasonable juror have found that the course of conduct
Before you get
inflicted?
to that, I understand your point there, and I'm sure we all want to hear that, but before you get to that, in this course of conduct, at what point does the defendant have to satisfy the relishing requirement?
So, Your Honor, there's no distinctive point within the course. The course itself has to evince the depravity. And again, I think that we have from the nature of the crime to the method of the crime, all the way to those post-slaying statements, defendant's depravity is stamped all over this crime. Again, they choose to wantonly target anyone who happens to be walking in the Little Italy neighborhood.
So you mean during the planning meeting, they're already relishing the idea of this?
I believe that they're
Action they're going
evincing
to take?
depravity from the very beginning, yes, Your Honor. And I think depravity here can mean, engaging in this wanton behavior. And again, the plain language of the statute is that it is a cruel and wanton course of conduct. Wanton typically is taken to mean, sort of an unprovoked, undirected violence. There can be nothing more wanton than saying we're going to go out and find someone just because they happen to be walking in the neighborhood and look like they might be of a certain race.
The statute defines depraved, so can you tell me how that conduct that you're referring to now fits within the definition of depraved within the statute, which is defendant relish the infliction of extreme physical pain upon the victim, evidencing debasement or perversion? How is that preamble, that preparatory stuff depraved?
So again, Your Honor, we look to the circumstances to determine the intent. It's very rare that a defendant speaks their intent, sort of out there in the air. So when we look to the fact that this is a grown man who joins with a group of other grown men to go out and target whomever happens to be walking down the wrong neighborhood street at the wrong time, and then proceeds to chase that young kid, brutalize him.
That goes to me to a general understanding of depraved. If you ask me, is that depraved, I would say yes. But they defined it in the statute to have this relish and took pleasure, because you can be depraved, want to do these things for revenge, to send a message to a rival gang, to do all these things which don't fit within this definition, which is relish and take pleasure in the infliction of pain, which seems to be getting at a specific thing under this umbrella of torture. So what is your best evidence that this person relished or took pleasure in the infliction of this pain?
Your Honor, I think the best evidence are the post-slaying statements, where defendant just seconds after brutally slaying this 15-year-old by savagely cutting his neck wide open, jumps in a car and says, I got him good, he's not going to eat for a while. But to back up, I would say that respectfully I disagree with Your Honor's assertion that the forms of depravity you mentioned wouldn't be covered here. Depravity here is defined as debasement or perversion or pleasure. And because that's not an ultimate fact, but an evidentiary fact, the jurors could have disagreed about which one of those they found.
With respect to the statements after the fact, could they also simply be consistent with, I accomplished the mission? And that is what it is, as opposed to the infliction of the pain itself.
So I would respond with 2 points, Your Honor. The first being that defendant hops in the car seconds after. So this is very close in time. So when we're thinking about his state of mind, he's not yet even coming down off of what he's just done. He's speaking with elation. The second thing I'd point out is that there's no gang leader in the car he jumps in. This isn't the moment where he will go up to his gang leader the minute he gets to his house to let him know he did it, but this isn't that moment. The first statement he makes is just seconds after, when he's surrounded by regular other, Trinitarios, not by a gang leader. So he's not there to take credit amongst the people who just witnessed him do this.
So the credit is the evidence of pleasure, is what you're saying?
No, Your Honor, I'm saying that because we know this statement is made where there's no real credit to be given, there's no gang leader in the car to say good job, that it evinces very clearly his pleasure in what he's done, his relishment in what he's done. And we cite to a host of other cases.
Your point is you don't need that in this definition, that you can have debasement or perversion or take pleasure or relish. But to me, it seems like debasement is at least informed by the rest of those things. So in the context of that sentence, how would you define debasement?
So again, Your Honor, I'm not going to fight the plain text definition here, which is that can be shown in a variety of ways, which would include the pleasure, the depravity, and the perversion. Here, we've argued primarily pleasure, though I do think, again, a jury could have found and not even had been, pardon me, the red light's on, may I finish?
Of course.
A jury didn't even have to come to a unanimous decision about which of those three forms of depravity they found here. I do think that pleasure counts. I think debasement counts. And I think that we can see both of those in defendant's conduct, the selection of methodology here, the needlessly brutal techniques they employed, and his post-slaying statements.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court, my name is Stephen Feynman. I represent the defendant.
I'd like to address first the people's argument with regards to course of conduct under the statute. Course of conduct requires, at the very least, 2 acts, and both those acts...
Where's your authority for that?
Excuse me?
What's your authority for that?
From the plain and clear, unambiguous language of the statute. The statute specifically states it has to be intentional, and has to be the intentional infliction of extreme physical pain, has to cause extreme physical pain, and that the defendant, and in here, the co-defendants all had to receive perverted pleasure, relish.
The jury have found that here, just looking at the course of conduct during the attack, where there are multiple stab wounds that aren't fatal over the course of whatever period of time, and then a fatal.
No, absolutely not, with all due respect. No.
Giving them every fair inference from the physical evidence of this crime, which we have to, since you have a jury verdict hearing.
According to the forensic evidence, Dr. Rodriguez, the medical examiner, she specifically stated all those injuries were superficial. Only the top part of the skin was damaged.
Let's say you have somebody and you're cutting them, and you know it's superficial, and then you're waiting while they suffer through superficial knife wounds, and then you stab them in the throat. That can't be a course of conduct?
That's not the facts of this case.
They couldn't have found that based on this.
No, there was no evidence to indicate that.
And so you're saying because the wounds were superficial, there is no pain?
There is pain, but not extreme physical pain. The medical examiner was not even asked that by the prosecutor.
But why couldn't the jury have found that just as a matter of common sense?
There was absolutely no evidence to support that. It was just superficial. The doctor said they would need no medical attention, maybe antibacterial cream. In addition, that's not sufficient according to the statute. You have to have the intention to cause extreme physical
Couldn't
pain.
superficial been used in a medical term as to the layers or the ability to be close to death? It doesn't necessarily mean that what the statute requires with respect to the pain that was felt by the person receiving those cuts, one after another.
Again, I just have to rely upon the record and the testimony of the medical examiner, which was the only evidence. There was no evidence to indicate that those injuries caused anything that possibly could be interpreted to be extreme physical pain.
Because of the word superficial? Is that why you're saying
It's only
that?
the top layer of the skin. It did not cause any other type of complication. This is nothing like the 2 leading cases, Peeble against Williams and...
How many layers of skin do you have to get through to feel the pain that's required?
I'm not a doctor, but according to the record, there was no evidence of extreme physical pain.
So is it your position, I'm sorry, is it your position that more than one action has to cause extreme physical pain? Are you saying 2,
Well-
there have to be 2? Or, yeah, I understand you're saying 2 for a course of conduct, but like, there was extreme physical pain here with that final slice to the throat. So you're saying that's not enough. So does every act in that course of conduct, do you read the statute, has to cause extreme physical pain?
Every act has to be intended to cause extreme physical pain, and then there has to be at least 2 acts that cause extreme physical pain.
Why do there
according
have to be
to-
at least 2 that cause extreme physical pain?
Excuse me?
I'm sorry. Why did there have to be at least 2 acts that cause extreme physical pain? I could understand the people's argument that there are acts leading up to the infliction of extreme physical pain, and that there has to be at least 1. And we could debate whether or not superficial knife wounds are extreme physical pain or not. But why is it that you're saying there have to be at least 2 acts inflicting extreme
According
physical
to
pain?
the statutory interpretation, the bill jacket specifically states that the course of conduct requires a series of distinct acts. The series of distinct acts has to be at least 2, and those 2 acts has to satisfy the definition of torture under the statute.
So
I'm sorry, go ahead.
No, go ahead.
Go ahead.
I think that your adversary, as I take it, is arguing that you can have a series of distinct acts which don't involve any physicality at all, but are simply about planning whatever the physical action is going to be. And I hear you saying, no, I think the statute requires that there be more than one physical act that inflicts extreme physical pain. Do I have your reading right?
That's correct.
And what in the statute or the bill jacket tells us that that's the right reading and your adversaries is not?
Well, the statute eliminates psychological pain and non-extreme physical pain.
But I think your adversary is saying the planning that culminates in a single act is a course of conduct. And I think you have a different view, so I'm trying to understand why.
The course of conduct, according to the bill jacket, is a series of distinct acts intended to cause extreme physical pain and does cause extreme physical pain. So from that definition, there has to be at least two acts. In this case, there's only one act that the people could identify that caused extreme physical pain. That was a knife wound to the neck. However, that would not satisfy the definition of torture because then we have the pleasure issue.
Before we get to the pleasure issue for a minute, you said something that I may have misheard, but I thought you said that as to the course of conduct, you had to have at least two acts that themselves caused extreme physical pain and were intended to cause extreme physical pain, and that every act in the course had to be intended to cause physical pain, whether it did or not. Did I mishear you?
No, that's correct. That's the plain, unambiguous language of the statute.
So that if there were 20 acts, 6 of which caused and were intended to cause extreme physical pain, but one of the 20 was not intended to cause extreme physical pain, this wouldn't be a course of conduct.
That one act would not be part of the course of conduct, and I would just compare this case.
I understand now. Okay.
Okay, I would just compare this case to.
You would just remove that from the course.
Right,
I understand.
but this is part. That will be evidence as to the. That it would be just evidence as to possibly like intent.
So let me ask you this. A defendant who decides that they want to use electric prongs on someone is going to purchase these prongs, wherever they purchase them, part of the course of conduct?
No, you have to actually have the act of intending to, you have to have the intent to use the prongs to cause extreme physical pain. You have to use the acts to cause extreme physical pain, and it has to result in extreme physical pain.
That's what I'm saying. The individual goes to, again, purchase these prongs wherever they're going to purchase them. The intent, they've got the individual they want to torture in the basement, tied up. They went to purchase the prongs, they bring the prongs back, they get them ready, and they use it on the individual. Let's say they only use it once and the individual dies of a heart attack. Let me give you an easy one.
That wouldn't satisfy the statute.
Why not?
Because none of the elements of the statute would have been satisfied. These elements.
What's missing? What's missing? Because when you purchase, that doesn't inflict, in that moment doesn't inflict physical pain?
That's correct, but that type of evidence deals with possibly intent. Let me explain. Like in People Against Williams, the individual had the victim for 19 hours, just like in Valdez, basically held them against their will. And in those 19 hours, he committed heinous, brutal crimes, vicious attacks upon her, cutting her eyes, pouring acid on her face, boiling water. I mean, I could go on, but I'm sure we all know the facts. There was also comments that the defendant made during this. The comments like, she's too good, she's not good enough to die soon, so I want to prolong.
Well, is your position that the only time the people are going to satisfy the requirements for the torture statute is if they have that kind of conduct that rises to that level?
According to the elements of the crime, yes. According to this statute has been around for almost 3 decades. There's been only maybe 3, 4 reported cases in that time because it's extremely difficult to satisfy the elements. The people have basically rewritten the statute in order to fit their facts. They're claiming that all you need is basically psychological suffering or non-extreme pain.
If one of the, apart from the final knife cut to the throat, if one of the other knife cuts the medical examiner had not said was superficial, would that have been then enough?
If there was evidence that one other act
Yes.
by one of the co-defendants
Yes.
intentionally caused,
Or even by this defendant?
intended to cause extreme physical pain,
Yes.
and he caused extreme physical pain,
Yes.
and then the defendant and the co-defendant relish the causing of that pain,
Okay.
then the elements might have been satisfied.
You haven't spoken that much about depravity, because we
Right.
keep getting stuck
Right.
on this course of conduct. So here, the argument is the depravity can be evidenced from statements that were made after the fact that seem to suggest that there was a certain level of enjoyment in the act. Why is that not sufficient?
Well, the only comments he made was that I stuck him in with a knife, that he's not going to eat for a while, I stuck him in a knife.
Well,
That
good.
was made, I would disagree with the prosecutor's comments. It was made to leaders of the gang. He was on probation, he wanted to get off probation and become a full gang member. So it was not, he didn't say that because he was pleased, causing extreme physical pain upon Junior.
Well, why
That
can't
was
it be both? Why can't it be both? He wanted to get promoted in his gang, and he did relish it.
He only spent, through the whole process, 6 seconds. He immediately left. He didn't even know what the extent of the injury was. All the defendants left immediately.
Sorry, how does that relate to depravity, not knowing what the extent of the injury is?
Well, you have to relish the pain that you just inflicted, the perverted pleasure.
Oh, so you're saying he wasn't around long enough to enjoy the fruits of his labor?
Well, yes, according to People Against Williams and People Against Valdez, the defendants were there for a substantial period of time, and they actually stated that they enjoyed it. In Valdez,
That's not a legal requirement, is it? I
in
mean,
the statute, it is.
I mean, isn't the question really whether his comments allow for an inference that he enjoyed it? Because they can be understood as bragging about it, right?
Bragging is nothing, all due respect, bragging is not relishing.
That's a
causing-
fair point, but isn't the question, do I enjoy this only because it gives me status in the gang, or is it fair to infer, or is it possible to infer that I also enjoyed it because I took pleasure in doing it? Why is that second inference not permissible?
I don't believe there's a reasonable inference that the jury could have relied upon from the evidence to reach that finding, and it has to be beyond a reasonable doubt. These comments in Valdez Cruz, the defendant is heard in telephone conversations recorded where he basically told the victim, I'm going to torture you, I'm going to pop your eyes out, I'm going to
Yeah,
basically...
but surely that's not a requirement. One could, or maybe you have a different view, but couldn't a defendant say something after committing a series of acts which makes clear that there was pleasure taken in inflicting the pain?
Obviously, yes, but each case has to,
Please finish, yes.
each case has to be rely upon the evidence. And in this case, there's no such evidence for that inference to have been made.
Chief, with your permission, I think it would be exceedingly rare, I'm not sure, but I think it would be exceedingly rare for someone who inflicted extreme physical pain upon someone to articulate either out into the air or even to their gang boss, I really enjoyed the infliction of that pain. I don't think you'd get that in the real world. And if that's the case, by your reading, it seems to me as if you might never get a conviction under this section. just, and I know you're ready to rebut right there, but what seems more likely to me is that you would go to your boss and say something like what one of the co-defendants said here, which is, I really got him, I got him good. And it sort of communicates to your boss, not only did I do the job, I enjoyed doing my job. I think those are two fair interpretations of that kind of statement. Why not?
Because job performance is not the issue. It's normally, I would say, again, there's only been a handful of cases in almost 3 decades, but it's really the circumstantial evidence. Did my client and the co-defendants, after the junior was stabbed in the neck, did they stay there and watch? Was there any other evidence to indicate that they really, truly satisfied the elements of the statute and relish the very fact that they caused extreme physical pain? I would believe...
Can I, Judge?
Of course.
You keep mentioning the Valdez-Cruz case. In that case, the evidence was that the woman's neck was cut open, and there was evidence that there was hacking and twisting of the knife while she was still alive. Each one of those arguably would have caused extreme pain. Would that have been enough in that case without the eyes, without everything else that happened, without the hours that he held her? Would you consider that a series, a course of conduct?
Well, in Valdez-Cruz, he also stabbed her eyes.
No, I know that, but I'm saying only on the neck. There was evidence that there was twisting and hacking of each or many of the blows, in addition to the one that ultimately killed her. So I'm saying each one of those, would you consider that a course of conduct? Because each one of those, I'm sure, caused extreme pain.
There was numerous acts, and yes, and in that case, the medical examiner specifically gave his expert opinion that those injuries caused extreme physical pain.
So in that case, just what happened in the neck would have been enough to sustain a torture or murder one?
Well, no, not just the neck. There was
No, I know what it was, but I'm asking you, would it have been enough?
No, because in that case, there was also, in that case, the defendant also stabbed the victim in each of her eyes, numerous head blows.
That. Again, I'm just focused on the neck.
One act is not sufficient.
So that you would
at least
consider
two.
that one act. Everything that happened in her neck area, you would consider it as one act, not distinct acts.
Well, according to the medical examiner, there was a number of acts, and the number of acts did cause extreme physical pain, but did I answer your question?
Well,
I mean,
I don't think you did.
I'm just saying the neck, there was medical evidence that the neck injuries, there was twisting, some of them were twisting motions, some of them were hacking motions. I'm sure each one of those caused extreme pain. And what I'm asking you is, and then there was the final blow where her trachea was cut and she was deceased. Would that neck area, those actions, each hack, each twist, each, hacking at her, would you consider that a course of conduct, or would you consider that one incident that had to do with her neck, and you have to add in the eyes and everything else to get to a murder one?
because each of those stabbings was a separate act. I'll say they were all separate in the neck, but the medical examiner specifically said that she survived for a few minutes afterwards, and he indicated that all those actions caused her extreme physical pain. And then you also have the defendant who indicated that his intention was to torture her. He indicated that in a recorded telephone call, he said, I didn't want, as he was explaining to the victim, I don't want you to die in a car accident, it'll be too quick. I want it to last. And his actions clearly show that.
Okay, thank you.
Your time is up.
Just one comment.
Quickly.
If this court decides to reverse the appellate division's decision, I would just ask that this case get remanded back to the appellate division so they could do a weight review analysis. Thank you.
Thank you.
Counsel, could you comment on the medical evidence that was just being discussed in terms of the other injuries?
Yes, Your Honor. So the medical examiner here testified to, she felt confident about testifying to 9 sharp object injuries littered across Junior's body. The fatal wound to the neck, obviously, which bisected his windpipe and cut his jugular vein, from which he bled out, and she testified that he died of exsanguination, causing his body to go into shock before he died, slumped against the security booth at St. Barnabas. She also articulated that he had defensive wounds, and that he had various other wounds that she didn't feel confident describing as sharp object injury wounds because of the variety of other blunt force wounds and dragging wounds that the boy suffered when he was drugged from the bodega. And to turn to Judges Canataro, Halligan, and Singas's questions, under the standard of review here, the people are entitled to every permissible inference. So if there is a permissible inference that defendants' post-slaying statements evinced pleasure and depravity, the people are entitled to that presumption here under the standard of review. And I think that is clearly the case. I would also push back on defense counsel's statement that there have to be 2 acts. I think if you look at Penal Law 125-26, you see where the legislator has clearly made it at least 2 acts. Under 125-26, which is an aggravated murder of a child, there has to be a substantial infliction of extreme physical pain other than the fatal
But you're
wound.
sort of reading the words course of out of the language, right? It could have just said conduct otherwise. Course implies a course, right? Something more than one.
Absolutely, Your Honor. And the fact that it says the course must inflict implies that we look at the collective course as conduct. Again, I think some of Your Honor's questions about where do we parse that course reveal that it's kind of a futile gesture to say, is it when you buy the prongs with the intent to use them to inflict torture, or is it when you actually use them? We look to the entire course, and the intent is evinced through the entire course. Through the entire course of defendant's conduct here, we know he intended to brutalize a singular individual en masse with a group of men.
Mattered that the testimony was that the other wounds were superficial in nature?
No, Your Honor. And as the medical examiner clarified when asked by the prosecutor on follow-up, superficial is just a medical term. May I briefly finish, Your Honor?
Of course.
Related to the depth of the wound. Here, the jury also saw video evidence and heard from multiple eyewitnesses about Junior's screams of stop, help. They saw the boy writhing on the ground. They saw the fear in his face. There were ample other bases for this jury to believe that he had been suffering extreme physical pain even before the fatal neck wound. And again, where the people under the standard of review are entitled to all permissible inferences, we believe we should be entitled to that inference as well. Thank you, Your Honors.
Following these arguments, the court affirmed the appellate court's decision, agreeing torture had not been proven. The court agreed with the people that the appellate division erred by concluding one element was not proven, but they found the second was not. What do you think of this case? Should it be so difficult to prove torture has taken place? Let me know what you think in the comments below, and if you like this video, please subscribe for new arguments every week. Until next time.